morning, Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Ruggs.
All right. This is going to be a waiver.
That is correct.
Mr. Ruggs, you signed this examination waiver?
Yes, I did, sir.
You understand that?
At first, this hearing looks like nothing more than routine courtroom paperwork, but don't let that fool you. Within minutes, a simple bond discussion will take an unexpected turn that completely changes the defendant's situation.
Preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
And you understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following. Read.
Thank you. We would acknowledge receipt of the information, waive any further reading, and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
27th at 1:30 for Judge Slate Thursday.
June 27, 2024, 1:30 Slate Thursday. Bond with its conditions will continue. Thank you. Yes.
For the note in my file from the other APA that you saw in violation review, that's today.
Yeah.
The May 17th, 2024 bond violation report.
I do. Is there a reason why you were missing? You were testing elsewhere, weren't you?
No, sir. I was told I needed a court order, and I was on video Zoom with you on my last court order, and nobody contacted me and told me where to go.
Why didn't they?
I do have information about a facility that he would like to test at. He lives in Macomb County. We
Yeah, I'm on GPS. Oh, I'm sorry.
called them and they indicated as long as the order indicates what sort of panel needs testing and the frequency.
Well, that was supposed to be done before. If I give you a test today, are you going to test?
Yeah, the only thing I'm gonna.
Here's something worth paying attention to. The defendant openly admits he'll likely test positive for marijuana while explaining his past struggles with addiction. Judges often appreciate honesty, but honesty alone doesn't erase the obligation to follow court-ordered bond conditions. Do you think his explanation deserves leniency?
Therefore, it would be marijuana.
Why are you using that?
Can I speak freely?
Yes.
Your Honor, I'm gonna be upfront honest with you. I used to have a crack cocaine addiction, and I've come a long way. I've been through a lot, this past few months. I lost my father, my grandmother. And there's no excuses. It's just the only thing that I've helped to.
Give me an order. Okay, he's going to go over to community corrections test today. I'll get the results and then I'll determine what his bond will be as he proceeds up, because he's told me what's going to happen, and then we'll figure out. In the meantime, counsel can prepare an order so that he can test in Macomb. Okay.
Okay. And then just to be clear for the record, the waiver is complete and we're only coming back on whether or not he'll be remanded.
Pardon?
The waiver's all set now?
Well, technically, no,
Got it.
because technically to retain jurisdiction, but I still have jurisdiction anyway. So he needs to go over and test, and then we'll figure out what we're going to do.
Okay. Thank you.
Thank you.
Thank you, Your Honor. Nicole Hughes on behalf of the people.
Sylvana Reed.
Just when everyone thinks the hearing is over, something unexpected happens outside the courtroom. Sometimes the most important development in a case doesn't happen during testimony, it happens in the hallway.
Assistant Public Defender with and on behalf of Mr. Ruggs.
As we were walking out of the courtroom, I went to release the deputy who was present. I did not believe that the victim of the domestic violence was present today because she didn't check in with us. As we were leaving, the deputy let me know that the victim was actually present today with the defendant sitting beside him. As we exited into the hallway so that I could see who the deputy was referring to, the defendant was speaking to Ms. Perkins out in the hallway, and the deputy confirmed that that is the victim. There, as I understand it, based on everything that's filed, there's no contact with her. That, in addition to the corrections violation,
This is a major legal issue. In many domestic violence cases, no contact bond conditions are taken extremely seriously. Even brief, seemingly harmless contact can be viewed as a violation if the court has ordered the parties to stay apart while the case is pending.
Requesting that he be remanded and that his bond be revoked.
That's not my problem. She was in court.
Mr. Allen, thank you, sir.
Your Honor, I have no further information at this time.
Does he admit to the violation?
You're on. Actually,
If you wish.
she wasn't here with me today, Your Honor.
Were you talking to her in the hallway?
She made a comment to her in the hallway. We were talking to her about testing, and I said something that I didn't.
Were you sitting next to each other in the courtroom? You know I can get video from the courtroom.
Okay, I
So-
understand that.
Notice how quickly the judge shifts focus. Only moments earlier, the discussion centered on drug testing. Now, after learning the defendant was sitting beside the alleged victim, the entire hearing becomes about one question. Was the court's no-contact order violated?
Yeah, she was sitting next to me.
You're not to have contact with her. You know that. Forget the testing. Defendant's bond at this time is revoked. Defendant's remanded. It'd just go up before Judge Slay.
In the end, the judge revoked the defendant's bond based on the alleged no-contact violation, meaning he would remain in custody while the case moved forward. Bond conditions aren't suggestions, they're court orders, and violating them can have immediate consequences even before the underlying charges are resolved. What do you think? Was revoking the bond the right decision based on what happened, or should the judge have looked deeper into the circumstances? Let us know your thoughts in the comments.
I'll just leave it there.
Thank you.
Your Honor.